As long as that's going around. There we go. We got a full house.
Jamie, can you still hear me?
I can hear you. Yes, I can.
I seem to have lost the rest of the committee.
Oh yeah, they're gone.
Yeah, I've just got you and Penelope on screen and
That's all I've got as well.
Ah.
Can you hear me?
Yeah.
yeah, loud and clear.
Okay.
I wish I could say this is all that matters, but I don't think we can say that. It says we're still there. We're live on YouTube, so maybe we're live, but they aren't. I'm not sure. So.
Yeah.
Oh, here we go.
Good evening, everyone. Can you hear me now? Jamie?
Yeah, we can hear you.
Paul?
We can hear you. We just can't see you, right? Oh, there you are.
Okay, well, that was a benefit, but now you're paying for it. And Penelope, thank you all for being here tonight. Welcome guests. Township of Nipissing Committee of Adjustment for Tuesday, August 17th. I'll ask first of all if there is any disclosure of pecuniary interest. Seeing none. Okay. Number 2, resolution to adopt the minutes of the meeting held July 13th, 2021. And I need a mover and seconder, please. I'll go to that side. Thank you. Moved by Councillor Kirky. Seconded by Councillor Scott. That we adopt the Committee of Adjustment minutes of July 13th, 2021. All in favor? Carried. Thank you. We move on to number 3 tonight. Consent application C 2021-06. Paul Goodrich on behalf of property owner Todd White. And I have the resolution here, and I will ask if anybody has any comments to make. And Penelope, did you want to say something? Yes?
Yes, if I could. Actually, Mayor Piper, I'm really pleased that both Paul and Jamie are here, because in speaking with the township staff, a lot of the information was really cleared up, but there are some concerns that I have, which I'm not sure if I'm just not understanding it, or if they're concerns that maybe we can think about. I'm just going to read because I jotted the different sections down. So in the planning report, the I guess it's page 6 of the planning report, which it references in the actual official plan, section 6.7.4.1L. It's page 6L in the planning report. It states, it is the policy of the plan to permit a maximum of 2 consents from any parcel in existence on or before October 11th, 1996, which I'm thinking might have been when the first official plan was. I'm not really sure. This policy, and this is the statement I'm thinking of, this policy shall not apply to development in settlement areas, which the flip side makes us assume it does apply to other areas. Prior to this application, there had already been additional lots created from the original parcel. And because the recommendation states, in our opinion, that the maximum lots referenced in this section of the OP applies to rural/non-shoreline lots and does not apply to shoreline areas. But that statement, in my mind, doesn't jive with the statement in our official plan. Because the only thing that's exempted in the official plan are settlement areas, which are just the 3 areas.
Jamie, would you love to comment on that?
Certainly, Your Worship, I'd like to Member Wallace, I can hopefully provide a bit of clarity. And certainly, under a plain reading of the language in that section, it does state specifically in the last sentence that it doesn't apply to settlement areas. So one could read it to mean that it does apply to all other areas but settlement areas. The reason for our opinion on this specific section relates to a couple of things. Relates to considering it first in the context of the provincial policy statement, and then secondly in the context of the broader context of the official plan. And why I state that is that from a provincial, and basically here's the thought process and how it breaks down from that perspective, is that from a provincial policy perspective in rural areas, so basically shoreline areas are included in rural areas, lands outside of settlement areas are included in rural areas or rural lands from a settlement or from a PPS perspective. The permitted uses are limited rural development, or now it's been changed, sorry, to locally appropriate rural development. And then also permitted use is resource-based recreational development. So basically, if you're in outside of a settlement area, not in a shoreline area, the development we see across the countryside would fall into that category of locally appropriate rural development. If you're on a shoreline, it would fall into that category of resource-based recreational use or cottage style development. So from a policy perspective, both the PPS and in the township official plan consider shoreline areas differently than they do rural areas. And from that perspective, there is a qualifier in the provincial policy statement about limiting the amount of development in those rural areas. There's no such qualifier as it applies to shoreline areas. So in that regard, it's our opinion that the municipality's official plan is to be read in the context that there is a limit. There's intended to be a limit on the amount of lot creation from both parcels, which is here in item number L, and then total lot creation, which we find in a subsequent section in the plan, which limits it to 10 per year. And then, but when we apply that previous policy framework I've identified to shoreline areas, we don't believe there's such a qualifier that restrictive of 2 consents per year should apply as it relates to shoreline areas, that they need to be treated differently, shoreline and rural areas. So that's a bit of a long-winded answer, but that's really the basis, is that provided from a lake capacity perspective and provided from a zoning perspective that shoreline lots meet the requirements of those documents. We believe additional lot creation along shorelines is appropriate as that resource-based recreational development. So that's kind of the big picture aspect of it. But I can certainly appreciate that last sentence that's included, that it could lead one to think that if it's not to apply in settlement areas, it is to apply to everywhere else. So I would suggest that there could be some clarity provided in that section of the official plan whenever there's a housekeeping update. But it really also speaks to the whole reason for recreational based development in the province and why lakes were opened up back in the day for shoreline and recreational based development. That the bylaws set specific controls, and so does the official plan in terms of environment and lake quality and those sorts of things. And from that perspective, we believe it's met. So I know that's a long-winded answer, but that's really the basis for that line of thinking. So I thank you for that.
Thank you, Jamie. Penelope, was there anything else?
And probably the expertise will come quite similarly. That fully explained it. It was that last sentence that was really catching me. The next one it's the actually the one right preceding it, where the planning report says the creation of the severed and the retained lots will not have the effect of preventing access to or landlocking any other parcel of land. And again, the recommendation states that the proposed lots would not affect existing access to any other lands. But the way I'm looking at the plan and the lands is it would appear that there's a driveway that actually is on Elsas, begins, it looks like on Elsas Road. It cuts across what I think is a previously severed land, going on to lot 1. And then well, I'll just step back just one sec there. So that's what the recommendation states, but the application itself actually states the application proposes an easement gap severing over severed lot 1 in order to access severed lot 2 and the lands south of the subject lands. So it would appear without this easement, the lands south of the subject lands in particular would be prevented access. So to me, those two things seem to contradict each other a little bit. So not only is the proposed easement required to prevent the southern lands from being inaccessible, it apparently is also being proposed as the access for both lots 1 and 2. It's my understanding that all new lots front on a municipal road or highway, and MTO does their thing with their recommendations and approvals, and the driveways, that's how you access the lots. In this case, the applicant's requesting that rather than construct a private driveways coming off of these new lots, off of Elsas Road for severed lots 1 and 2, and I'm not even sure what the retained lot is. Proposed access would be via this proposed easement, which would connect to an existing driveway on a totally different previously severed lot, run down severed lot 1, run across severed lot 2. There's just a little juncture there, and then continue on down to access the land south of the subject land. Am I interpreting that correctly?
Maybe I can help your worship through to Ms. Wallace. Yeah, I just, to provide a little bit of clarity and is that the section in the official plan that relates to frontage on a municipal road, it does speak to that all new lots need frontage on a municipally maintained road. It doesn't specifically say that they need frontage and access from that municipally maintained road. direct access from it. So in this case, access does come from Alsace Road, and it is proposed through an easement. Easements are common, and I guess before I get to the commonality of easements is that the benefit to the easement in this instance is it does provide legal access to those properties to the south. And that's really the focus here, and the intent of these policies is that to ensure that new lots have legal access so that it doesn't result in landowner conflict in the future in terms of who's maintaining things and do you have a right to trespass over someone else's property. The easement does provide that legal ability. So that's point one. From easements are something that's common, especially in shoreline areas and in lake-based municipalities for providing access, and common and shared driveway access are common. The real reason for that is that it does reduce, there's a cost associated with it, obviously, for putting in longer driveways. But also it reduces the amount of site alteration that's necessary and removal of trees or crossing of water courses, or just general ensures that more of the land is maintained in its natural state if there's less driveways associated with the property. And from an intensity of use perspective, the intensity of use and the amount of trips associated with these entrances and driveways are such low volume that there's no concerns from a traffic perspective in terms of having multiple properties with one entrance onto the Alsace Road. So if I could summarize it, the focus is ensuring legal access is item number one, which is achieved here, both for the severed and retained, but also the properties to the south. The second key point is related to ensuring that limiting impact on the environment and limiting tree removal and site alteration. That's the second key point. And then the third is just related to, from a traffic movement perspective, less entrances on the Alsace Road, and certainly the infrastructure is capable of accommodating the limited amount of traffic generated from these proposed entrances and easements. So I hope that helps to provide a little bit of clarity on that issue. But from that perspective, we believe that the policies, the official plan related to access and frontage on a municipally maintained road are met and are conformed with. So
That was very helpful, actually. My last one has to do with North Bay Mattawa Conservation Authority, because I realize the application has been circulated to them. Nothing, I guess I should ask that as a question. To the time that we received our information, nothing had been received back from them. Has anything been received back from them yet?
I'll maybe just put this to John Paul if he's received anything, or Paul, I have not seen anything yet, but I can elaborate on that question if the answer is no.
It's no from me.
John Paul, have you received anything from North Bay Mattawa?
I think in this scenario, like, it's be conditional for approval.
I see, okay.
You have a year to meet that.
So maybe I can just speak to that in a little bit more detail, Member Wallace. Where lot creation is proposed and where the size of lots or the extent of what we see here, it's completely common to approve lots on condition of receiving approval from the North Bay Mattawa Conservation Authority. So it could be a condition of provisional consent in this instance. Certainly, I would fully expect that there would be an opportunity to site a septic system on each one of these lots. They're extremely large in size. Have never, in my experience, I've never seen a lots that are this size that have not been able to accommodate a septic system. And I would assume Mr. Goodridge would be of the same understanding, and that's working throughout the Parry Sound District. So hopefully that helps as well. But in this instance, it's completely reasonable to include it as a condition of provisional consent, the North Bay Mattawa sign off. So
Jamie, at the very beginning of the the planning report, which Paul, I'm assuming, was on the application as well. It states that the application also proposes, no, that's the wrong section, just a second here. It's on page 2. It says the single unit dwelling is serviced by privately owned and operated communal well and septic tank. Severed lot 1 and the retained are proposed to be serviced the same way.
Yeah, I can clarify that through you,
Okay.
Your Worship. That was the box that was checked off on the application form inadvertently, and we've since confirmed that with Mr. Goodridge that the properties are serviced by individual on-site well and septic system, or sorry, individual septic system. So it is not proposed to be communal. So,
Okay. So in the conditions, can all of what you've suggested from the North Bay Mattawa Conservation Authority, all the things that they would cover, I think, if I'm understanding correctly, they can all come under conditions then?
yes, there is actually in the decision, one of the recommended conditions that's included in the draft decision, and it's included at the conclusion of the planning report. It's item number, so it's item number D, I believe.
Yes.
It does state written approval from the North Bay Mattawa Conservation Authority confirming that each of the proposed lots are suitable size and configuration to accommodate a new private on-site sewage and water services. So that is included as a condition.
Okay, no, that's great. Thanks very much.
Thank you very much for your thorough comments and review.
Welcome.
Councilor Kirky?
Yes, the question of the driveway. Well, that's an easement. How is that going to be maintained? What?
I'm sorry, how will it be maintained was the question?
Yes, whose responsibility to maintain that easement?
That's one of the benefits of having a written, registered, on title right-of-way document. In the legal agreement that gets written up, all of the maintenance responsibilities will be spelled out in that agreement, so that any purchaser of a lot will know exactly what their rights and obligations are under that agreement. They'll be, their lawyer will inform them of that once they've done the title search and found it. Historically, that road has been the subject of a right-of-way agreement between the original 3 property owners, which, if you recall, were all family members, but they did still put together a written document. Now, of course, we're getting outside people coming in to purchase some of the lots, and because the original document didn't require Planning Act consent because it was for a term of less than 21 years. But now with the additional development, it makes a lot of sense to actually have it registered on title against each of the properties so that everyone is well aware of that. And there's many different ways to share the maintenance. A lot of it comes down to who needs winter maintenance of the road. Mr. White, for example, lives in the dwelling on severed lot 1, right at the little point of land at the Narrows, where the bay opens up then into the broader section of the lake. So he is someone who would be interested, of course, in having year-round maintenance of that road. But those are the sort of issues that get written up into the agreement, and most good agreements, in my opinion, also have a mediation and arbitration process spelt out. The old right-of-way agreements, basically just said it was a right-of-way for ingress and egress, period. It never addressed those financial issues and the year-round issues or lack thereof. But a modern agreement for a registered right-of-way really should have all of those items addressed. Good paper makes for good neighbors is what the lawyers say. Us surveyors, we say good boundaries make good neighbors, but the lawyers say good paper. So if it's written properly right off the bat, it's a long-term benefit to all of the properties.
Good,
There
thank
is
you.
I'm sorry, there is also, even in the absence of an agreement, there is legislation in the province called the Road Access Act. It first came about in the 1950s to address primarily lot development in the Muskokas that had occurred by way of unregistered rights of way or agreements with the farmers. And although the farmer didn't mind the initial people, with the new people moving in, perhaps they weren't as respectful of his property rights. And then these access routes were being blocked off. And it was at that point in time that the provincial government brought in the Road Access Act. It's not a perfect piece of legislation, and the registered right-of-way registered on title gives far greater protection to all of the property owners than simply relying upon the Road Access Act, at least in my opinion. I'm not a lawyer, I'm a surveyor and a planner, but from my understanding and my experience in dealing with these, the Road Access Act is sort of a court of last resort if you have to go that route. But the recommendation that Jamie's come up with for the registered right-of-way, we fully support that as well. And to Penelope's point, the little side shoot off to severed lot 2, that was simply for the convenience of lot number 2. A lot of people don't like to be on a right-of-way with other people. They'd prefer to have their own driveway access. Because they have the frontage on Alsace Road, they have that opportunity to do so. Or if they would prefer lower maintenance costs, this at least gives them a little bit of flexibility in how they wish to proceed.
Thank you. Mr.
You're
LaFont?
That clarifies most of my questions, save and except what is the status of the easement at the moment, and are the people to the south party to any of the new parts of the agreement for retained and severed lot 2?
I'm sorry, pardon me, with respect to the severed 2, I'm sorry, I didn't catch that last bit.
How are the lots to the south of this application, who are party to an existing easement or right-of-way, how are they protected in the new agreement, the new right-of-way?
In the new agreement, registered rights of way will be provided across severed lot 1 for anyone who is any user of the road south of severed lot 1. We're hoping that everyone will get together on this, because we've got 3 lots now to the south out of the middle portion. The gentleman that owns the original lot further south has contacted me also about doing a similar application on his properties. So what we're looking to do is have a comprehensive solution for all parties involved, and we would survey the entire road. Hopefully, if everyone comes on board, we will simply survey it all of the way from Alsace Road right through the abutting lands to the south. Now, we will have to come back with separate severance applications on those properties. And of course, all of those property owners were notified of the application that's before you this evening. So if any of them had any concerns, now would be the time for them to have come forward and made those concerns known. But we will be addressing their concerns when we do the final survey of the current lots, with the committee's approval, and they will be addressed. So legally, it won't just be a right of way across severed lot 1 for severed 2. Legally, it will be a right-of-way for all current users of the right-of-way, or of the access drive, we'll call it, which will accommodate all of the users.
Thank you. That, one other small matter, there are no public access issues.
No, this is a private driveway. Now, it will be available to all of the users, and any of their, usually the language in the right-of-way document is that it inures to the benefit of the heirs, assigns, successors. Well, yeah, sorry, I'm not a lawyer, like I say, but typically it will run with the land, not with the private individual owners. So when they sell, any new owner will also receive the benefit of the right-of-way, but this is not a public road. It will still be a private road. There will be no right to the public to be driving down this road unless they actually are coming to see, they're a visitor of one of the property owners. It will be a private road.
Okay, thank you.
Does that cover everyone's questions? If so, with the conditions that have already come through that Jamie mentioned earlier, I would like a mover and a seconder, and we would move ahead with this. So do I have a mover and second? Councillor Kirky and Councillor Moore. Read the resolution. It's number COAR 2021-15. Moved by Councillor Kirky, seconded by Councillor Moore. Application C 2021-06. Applicant Goodrich Goulet Planning and Surveying Limited on behalf of Todd and Vanessa White. Decision, the consent application proposes to create a total of 3 shoreline residential lots. The Township of Nipissing Committee of Adjustment approved consent application C 2021-06 by providing provisional consent subject to the following conditions. That the applicant provides the township with a copy of the reference plans to be deposited in the land registry office that is substantially in compliance with the application sketch. B, the original executed transfers deeds, both duplicate and originals, and 1 copy per consent. C, a schedule prescribing the lots and naming the applicable grantor and grantee attached to the transfers for approval purposes. D, as mentioned, written approval from the North Bay Mattawa Conservation Authority confirming that each of the proposed lots are a suitable size and configuration to accommodate new private on-site sewage and water services. E, written confirmation that sufficient capacity exists for treatment capacity for hauled sewage to the satisfaction of the township. F, the property be zoned to require development and site alteration on the proposed lots to be located at least 120 meters from known fish habitat and from the adjacent unclassified wetland feature. And G, a certificate in the appropriate form prescribed in OREG 19796, Schedule 1 for signature, the Township of Nipissing Committee of Adjustment official, secretary, treasurer, or chairperson. Comments or questions? I'm going to call a vote then. All in favor? Carried.
Thanks, everyone, and thanks to Jamie for carrying the ball for me most of the evening. That was wonderful. Good night, everyone.
Thank you, Paul, and thank you, Jamie.
Hey, Jamie.
The only other thing we have for the meeting tonight is Committee of Adjustment meeting be adjourned. So a mover and seconder, Councillor Moore and Councillor Scott. So it's number COAR 2021-16, moved by Councillor Moore, seconded by Councillor Scott, that the Committee of Adjustment meeting be adjourned at 6:37 p.m. All in favor? Carried. Thank you, and John Paul, all you need to add is?